Hi everyone. Do you know what is the most important requirement for a contract to be valid in India? To understand that, let us discuss some of the provisions of Indian Contract Act 1872. So, Section 10 of Indian Contract Act lays down that all agreements are contracts if they are made by the free consent of the parties who are competent to contract for a lawful consideration and with a lawful object and are not hereby expressly declared to be void. Here, hereby means that in this particular act. For the purpose of this video, we are focusing on the persons who are said to be competent to contract. That brings us to section 11 of Indian Contract Act. Section 11 of the Indian Contract Act lays down three conditions where a person will be said to be competent to contract. First of all, he should have attained the age of majority. Secondly, he should be of sound mind. And thirdly, he should not be disqualified from contracting by any law to which he is subject. In India, we are subject to the Majority Act 1875. Section 3 of the Act lays down that every person domiciled in India shall attain the age of majority on his completing the age of 18 years and not before. So, the age of majority in India is 18 years. So, by now, we know that persons making a contract should be above 18 years of age. So, what if you make an agreement with someone who is a minor who has not attained the age of 18 years yet? Let us find out. Now we'll discuss the landmark judgment of Mohiri Bibi versus Dharmodas Ghosh. In this case, Dharmodas Ghosh mortgaged his immovable property to Brahmadatta and took some amount of loan from him. However, at the commencement of the agreement, Dharmodas Ghosh was a minor, and his mother had also informed Kedarnath, who was the agent of Brahmadatta, that Dharmodas Ghosh is a minor and he is not legally competent to mortgage his property and take loan from him. On attaining majority, Dharmodas Ghosh, along with his mother, sued Brahmadatta, saying that when the contract was entered, he was a minor and therefore contract is not legally binding on him and he is not liable to return any money which he had received from that contract. It was held by the court that since Dharmodas Ghosh was a minor during the commencement of the agreement is void ab initio, that is, it is null and void right from the beginning, and Dharmodas Ghosh is not obliged to return any money to Brahmadatta. Also, Brahmadatta will not get the benefit under Section 64 of Contract Act, which is applicable to voidable contracts and not void contracts. Let us understand the difference between void and voidable contracts. Void contracts are those which are not enforceable by law, means they mean nothing in the eyes of law. However, voidable contracts are those where one party can avoid the contract on the various grounds which are given in Indian Contract Act itself. For example, when the consent was obtained by fraud or misrepresentation. Next time you think of entering into a contract, make sure that all the essential requirements by the Indian Contract Act are fulfilled and both the parties have attained the age of majority, that is, age above 18 years.